Welcome to today's session. Thank you for your time and being here today. My name is Özbek and I'm Managing Partner at Özbek Attorney Partnership. I will have the pleasure to be moderating today's session. Today we are hosting the session together with KP, and I will turn it over to Burcu to welcome you on behalf of all of us. Burcu, please.
Thank you, Selin. Hello and welcome everyone. I am Burcu Özdamar, Senior Partner at Köksal&Partners Attorney Partnership. As you may know, KP Talks is a new discussion panel series, which is powered by the collaboration of Özbek and KP Data. Today we are having our first international discussion panel, where we will be discussing multidisciplinary perspective of privacy and data protection with experts. From now on, we will having this discussion panels every month on hot legal topics with professionals. In general, our discussions will be in Turkish, but once every 3 months, we are going to host an international event, which will be held in English. You can stay up to date by following our LinkedIn accounts. I would like to thank Selin for moderating the discussions and our speakers for joining us here today. I hope you find the panel beneficial and hope to see you at our next events. This is your turn, Selin.
Thank you, Burcu. Today we will be discussing various requirements and obligations for companies in UK, US, and in Turkey under different jurisdictions and legislation. Today's panel will be recorded and it will be available after on our both law firms' LinkedIn sites. We will also try to add the Turkish translation subtitles thereafter for those who want to follow the discussions in Turkish. Today we have a distinguished panel. I will introduce them one by one. They will have 20 minutes to discuss their topics, and then we will have a 30 minutes Q&A session at the end of the webinar. So please feel free to share your questions on the chat box at any time. We will try to answer the questions as long as the time allows at the end of the webinar. In today's panel, we have Katie Hewson from Stephenson Harvard LLP, Odia Kagan from Fox Rothschild LLP, Didem Kalaycıoğlu from Turkcell, and Can Ertürkmen from Getir. Didem will be joining us soon. She had some technical problems, but she will be joining us soon. So let me start with Katie and introduce her for all of us. Katie is the data protection partner at Stephenson Harvard LLP. She's a data protection specialist with significant experience advising clients across a variety of sectors and jurisdictions, and helps lead Stephenson Harvard's data protection practice. She is recognized as next generation partner for data protection, privacy and cybersecurity by Legal 500, and she holds CIPPE. She regularly leads international GDPR compliance projects, advises data practices, contracts, transparency issues, international data, personal data transfers, which is the hottest topic at the moment, data sharing, cybersecurity, personal data breaches, as well as direct marketing, ad tech, social media, and cookie issues under the e-privacy regime. She also acted for clients facing ICO enforcement, which is very well known by Turkish companies. They very closely follow ICO for enforcement action on potential data protection and freedom of information law breaches. Now, later Odia and Didem and Can will be joining us. For Katie, we have some topics, very interesting topics. She will be talking about what data protection and direct marketing rules apply to Turkish or other overseas organizations when they want to do business in the UK, what key challenges they face, especially after Brexit, what has been changing, what changes are on the horizon for UK data protection law, and how will that affect overseas businesses. Please, Katie.
Thank you very much. It's such a pleasure to be here, and your introduction made me sound very busy, and indeed it is such a busy and so many different moving parts at the moment in this area of law, so lots to keep up with. Yeah, I'm going to be talking about the key UK data protection law requirements that you need to be aware of as a Turkish business, either operating, I'm assuming that I'm sort of talking to people who might be operating from Turkey and selling into remotely into UK from overseas, and also Turkish companies who will have UK establishments as well. I'm going to look at the key UK law requirements and possible challenges and areas of change that we're all dealing with at the moment. We have this consultation, and I'll be referring to that as we go through, talking about the sort of areas that are potentially going to change for us as a result of that. So I suppose the first question I get asked is often sort of what even is UK data protection law now post-Brexit? How does it work? How does it differ from the EU version of the GDPR? And at the moment, we've retained the EU version largely sort of 95% exactly the same as it was. So we have the UK GDPR now. In substance, it's mostly the same. We've made some minor amendments to make it make sense in a UK context. So sort of references to member states are now to the United Kingdom, but otherwise we've basically got the GDPR still in force. And we still have our privacy and electronic communications regulations, which regulate direct marketing and cookies. And again, they haven't changed. That was always kind of national law anyway. They apply, so UK GDPR applies in the same way as the EU version. So either if you're established in the UK or if you're selling to or monitoring individuals within the UK, then you'll have to think about the UK version of the GDPR. So it will apply to you whether or not you're established in the UK if you're selling from overseas, from Turkey. I was looking at the Turkish data protection or understand selling from conversations with you. It's kind of, I think you're going to be familiar with a lot of the key principles and concepts, because I understand it's very aligned with the previous directive.
Exactly.
Yeah, so I don't want to sort of teach you all to suck eggs, but going through some of the kind of key differences, particularly from what I understand Turkish data protection law says, we've got the same idea of principles that you'll all be familiar with. So that you need, whenever you're processing personal data, you need to do so in a fair, lawful and transparent way, limiting it to the purpose for which you collected the data. You have the principle of data minimization, accuracy, retaining it for no longer than is necessary, and applying appropriate security measures. The key change that we all found moving to the GDPR was a sort of more emphasis on accountability. So actually being responsible for and actually being able to document the fact that you could demonstrate compliance with the principles. So that with it brought, I don't know to what extent you have this now, but that brought with it the new requirement for a lot of UK businesses for records of processing activities, data protection impact assessments, and mandatory data protection officers in some cases. So data protection impact assessments are required, as in Europe, in exactly the same way in the UK, where there's likely to be a high risk arising from the processing activity. And data protection officers, where your core activities, in the same way as Europe, will involve the processing of the special categories or monitoring on a large scale. So that's a sort of accountability program. The reason I'm mentioning this is in particular is because even though lots of organizations went through their GDPR programs a couple of years ago, now this UK consultation is talking about changing the requirements for this accountability program. The consultation, just to kind of give you the background, is the government is saying it wants to make it more business friendly, the UK data protection regime. So it wants to be less prescriptive about some of these accountability requirements. So it's proposing to remove the requirement for a record of processing activities in the UK, the requirement for data protection impact assessments, and the requirement to appoint a data protection officer. That it doesn't mean you can just do absolutely nothing. They're talking about some more bespoke, flexible solutions, and I think in any case there's going to be a need to do some form of impact assessment for riskier activities. It just seems sensible. We're not getting rid of the principle of accountability, but it's just apparently going to be less prescriptive what those things need to look like and what they need to cover.
Would it be fair to say that this would make UK a more attractive jurisdiction for international players when it comes to data protection law?
Yeah, I mean, I think that's certainly what the UK government is hoping. They want it to be a sort of Brexit dividend, that we are seen as a more business-friendly jurisdiction than maybe some of the quite prescriptive EU requirements. And that is great. And I think that is true, that they do, from their consultation, it's quite eye-catching changes. I think the downside is for any organisations that have a footprint in the EU or otherwise subject to EU GDPR, have done their whole GDPR compliance programme.
Yeah,
they're probably not going to want two sets of documentation, and they kind of need to do it all for the EU version anyway. So there's going to be that challenge, but there's certainly some opportunities there as well. Yeah, so the UK, just to kind of give you the buzzword, it's the UK proposal is called the Privacy Management Programme. So that's what we're going to have instead of these requirements, just in case you hear that somewhere along the way. Just to kind of touch on some of the other key requirements, the transparency principle has it brings some specific UK issues. So a lot of post-Brexit, we've had to do quite a lot of tweaks to privacy notices to make sure that they weren't talking about data not going outside the EEA. Because obviously, if it was going to the UK, because obviously now the UK is no longer a member of the EEA, but just like little things to be aware of on privacy notices for transparency purposes. And I was also going to mention as well, although this isn't UK, this is an EU development, but there are the WhatsApp fine from the DPC, 225 million, so big fine. And one of the key issues in that was related to transparency of WhatsApp's privacy notice. And we're seeing sort of market practice evolving, and that expectation in that DPC fine and the EDPB comments on that DPC fine were that you have to get really granular now on your privacy notices and tie your purposes and your legal bases and your categories and your data subjects together very closely to make it very clear what data you're processing, why, whose data it is. You can't just have the kind of general comments anymore and not make it clear what your legal basis, for example, for each processing activity is. So I just wanted to flag, although it's not UK and we don't know quite what the ICO thinks about that decision, it's clear that market practice is evolving to have sort of higher expectations of the privacy notice. It's not just something you can use a template for off the internet and then you're done anymore, unfortunately. If anyone ever did that, I'm sure they didn't. So to kind of carry on through some of the main principles, we still have all the same legal grounds as the EU GDPR, so consent, contract, legal obligation, vital interests, public interests and legitimate interests, and obviously that's your legal basis for processing personal data. And then obviously the additional ones are special category data. So I don't want to sort of take you through that in too much detail, but I wanted to mention one thing in relation to legitimate interest, because that's obviously a very common legal basis. The UK government consultation is proposing to make it a bit simpler and arguably slightly less burdensome to rely on legitimate interest in some cases. it suggests that it's going to have a pre-approved list of interests. You'll have to show that what you want to do is necessary for one of these interests, but you won't have to do this balancing test, whereby if you want to rely on legitimate interests, you have to show that your interests aren't overridden by the rights of reason of the data subject. The UK government consultation has proposed that sort of pre-approved balancing test interests will include some quite interesting ones, including sort of business innovation for improvements in services, which is actually one of those catch-all, and it could be quite a wide-ranging legitimate interest to rely on. And also a pre-approved interest would be monitoring AI systems for evidence of bias. So again, they're looking at, just briefly mentioned, they're looking at sort of regulating their AI regime and making that more, what can we do to make that more business friendly? I don't know if it's going to make a great deal of difference, but again, it all goes to show the UK government pushing for the whole regime to be more business friendly, essentially. Just going through some of the other areas that we still have pretty much exactly the same requirements as in the EU for the prescriptive things you need to have in a contract between a controller and a processor. So, audit rights, objection to sub-processor appointments, and making sure that your instructions to your processor include instructions in relation to overseas transfers of personal data. And that's a whole other complicated area that Odia likes to say that you should cry and pray about, because it is so challenging at the moment. And we could spend hours talking about this by itself, but just to kind of go into the UK approach, we still have the requirement under Chapter 5 of the UK GDPR now to comply with the requirements of that chapter when you are sending personal data to overseas. And if it's not going to an adequate country, then you either have to have one of your safeguards in place or a derogation must apply. So we don't have this ability to sort of, I think you guys might rely more on authorization and consent, and we can maybe hear a bit about that, but we would tend to rely on the classic one is the standard contractual clauses. We are in this quite strange and slightly annoying situation in the UK at the moment, whereby we're still using the European old directive standard contractual clauses that are now no longer valid for use for new European exports of personal data. So even though the directive is long gone, we're still using this document with the directive still referred to in it. You can make some minor amendments, again, to sort of cross out member state and put United Kingdom, but otherwise you've got this strange document you're still having to rely on. That is mainly annoying for multinationals, because they are already obviously updating, remediating their European standard contractual clauses, and they can't really do that at the moment for the UK versions, because the UK has made it clear, the ICO has made it clear that the new European ones are not valid for UK purposes. We have to stick to the old ones until we get a new UK approved version. They have published that in draft. I understand that they're hoping to finalize that ASAP and by the end of this year, just because it's quite a difficult situation everyone's in at the moment. We have the new UK SECs, they're calling it the IDTA, the International Data Transfer Agreement. It looks very different to the EU SECs that you're probably all familiar with. It's very much plain English. There's no kind of modular approach. It's designed for non-experts to be able to kind of go through and create it, so it doesn't look very much like a contract. It's quite pragmatic,
exactly,
friendly. It's all part of this. I think this push to sort of promote the UK data protection regime, but it is a different document to the European document. So if you are subject to both the EU and the UK regime on this, you're going to have to make a choice whether you put two documents in place or whether you rely on just the European document and the UK Consultation has proposed this thing called a UK addendum to the European standard contractual clauses. So you could potentially use the European version with a sort of an addendum, which is a couple of pages. It's quite short, and it basically says the European version will apply for and be valid for a UK export of personal data, but with some sort of the following amendments. And it basically, again, it makes it work in a UK context. So you'll read references to member states as being to the United Kingdom, that kind of thing. So there's going to be some decision making to be done there. Alongside the IDTA, the ICO has also published a transfer risk assessment, which is its view on how the Schrems II requirement to basically assess the impact, assess the risk of any kind of data exports that are relying on standard contractual clauses or other safeguards, assess whether that data is being protected to an essentially equivalent standard. I know there's a lot of questions. We've obviously got the EDPB guidance on what that means and what that requirement actually, the extent of that requirement to assess the law of the country of import and the practices in that country. And that is quite onerous. Again, the UK ICO has come out with a slightly more pragmatic approach to its transfer risk assessment equivalent.
Very useful, actually. Very useful. Very useful.
Yeah. What did you think of it?
I liked it. It's very pragmatic, really useful for businesses. To be honest, very, very innovative, in my opinion.
Well, that's good to hear. I'm sure the ICO will be pleased. There's lots of flow charts. It is very easy to go through, and I'm probably biased, but I think it's more user friendly than the European equivalent guidance that we've seen so far.
I would agree on that.
So it also even sort of temptingly suggests that if it's very low risk data, you can kind of almost not worry too much about what the legal regime in the country or the practices in the country of import are, because if someone gets their hands on very low risk data, it's not really going to matter anyway. Yes. I'm paraphrasing, but that's the kind of underlying assumption. So, and that's definitely not in line with what the EDPB guidance says. You know, any sort of non, GDPR equivalent standard access to data would not be allowed under that approach to the transfer impact assessment. So we've got a very different approach starting to evolve for overseas transfers. And we've also even got a potentially a different approach to what even is a transfer in the first place. Again, you could have a whole session about this, but the UK government is considering this, and I understand European authorities are considering this. EDPB is looking at what is a transfer. Is it when data leaves the protection of the UK GDPR? So, is it a transfer if it goes to someone overseas who is subject to UK GDPR, or is the main thing that whether it leaves the country and goes to a non-adequate jurisdiction? So is it a territorial or a jurisdictional thing? I won't get into that because it's very
it's very complicated.
Yeah,
but maybe before you finish, we can also touch upon direct marketing rules, because this is something that really interests Turkish companies who want to do business in UK, and absolutely. They have most of the time very concerned about it.
Absolutely. Okay, so the one thing I wanted to mention on the UK regime was the need to appoint a UK representative. If you don't have an establishment in the UK, you have the same requirement as there is in Europe to appoint a representative to basically liaise with the ICO within the UK. And if you have a EU rep, you might also need a UK one.
Okay.
And the other thing I wanted to mention in terms of DPO is that your DPO doesn't need to be based in the UK, but they obviously need to have sufficient UK specific experience. So coming on to direct marketing, the consultation is the rules are pretty much the same as in Europe, but the consultation is proposing to increase the potential fines. At the moment, the fines for electronic direct marketing and cookies breaches under the privacy and electronic communications regulations, potential fines for that are only £500,000 at the moment.
£500,000.
Yeah, but
we have to multiply it with 13 now, which is quite a big amount of money for all of us.
Yeah, yes, exactly. But you know, in comparison to GDPR fines, it's much lower. The consultation is proposing to align that so that UK, you know, marketing fines are going to be exactly the same as GDPR fines. You know, either 17.5 million pounds or for 2 or 4% of your worldwide turnover. The key requirement you need to be aware of when marketing to UK data subjects, that you need to have prior consent unless you have already, unless the soft opt-in applies, it's called. So unless you have obtained the details in the course of the sale to the same person or negotiations for a sale, and you're marketing similar services, and you've given them a chance to opt out at the time and in every message. So unless you have a relationship like that with someone, you need prior consent to send electronic direct marketing. So yeah, again, they might change it slightly in the consultation, but that is a key requirement. And actually, there's quite a lot of enforcement risk. That's a key area that the ICO really likes to fine people for. So it's definitely something to get right. Cookies rules are under the same set of regulations. Again, you need prior consent, and it needs to be GDPR level consent, so specific, freely given, informed, and obviously this is why we all see, you know, we're sick of our cookie banners with long and or sometimes not even compliant messaging about what you're supposed to be doing, but obviously that's with the aim of giving opt-in consent before any non-essential cookies are set. Just to say, in terms of the consultation, the UK government says it wants to, you know, ban these cookie banners, and I don't quite know what it means by that, but one of the specific proposals in the consultation is that it wants to allow analytics audience measurement cookies to be set on the basis of legitimate interest rather than consent. So that might be one way in which you don't obviously need a cookie banner if you're only doing audience measurement with your cookies.
Thank you, Katie.
That was my whip through of the UK.
Thanks a lot. We'll have questions at the end of the webinar. I'm sure our attendees have questions, so we'll follow that up. So now, Odia, let me first introduce her. Odia is a partner and chair of GDPR compliance and international privacy practice at Fox Rothschild LLP, a US law firm. She has advised more than 200 companies of varying industries and sizes on compliance with GDPR, California Consumer Privacy Act, CCPA, and other US data protection laws. With an emphasis on pragmatic, risk-based approach, Odia provides clients with practical advice on how to design and implement their products and services in a compliant manner. She holds 3 law degrees, 5 bar admissions, and 5 privacy certifications. No need to edit anything on that, I guess.
That's what you're trying to say.
She's very active on LinkedIn. I follow her and I enjoy following her. She always has great insight on things and new legislation. So you can always follow her on LinkedIn on her Odia Kagan LinkedIn site. Today she will talk us through what Turkish companies, or even maybe non-US or semi-GDPR companies, think about regarding data protection and marketing when doing business in the US. What are the pain points and concerns? As Katie mentioned, cry and pray. And what are the things to do now with all these changes globally? Please, Odia.
Thank you. Thank you very much. Really nice to be here. Thank you for joining this webinar. So I'm going to start with the marketing because that's pretty simple. And that's some good news for Turkish companies as differentiated from the European rules. So in the US, if you want to market via email, you do not need prior consent. You need to be compliant with the law that applies in the US is CAN spam. CAN spam is an opt-out law. You need an unsubscribe at the bottom of each email. You need that in Europe anyway. So you just need that and you don't need the opt-in. So that's easy. On the other hand, yeah, so emails are easy. On the other hand, if you are thinking of marketing via text messaging, via SMS, then it becomes more complicated. I would say talk to an attorney and to figure this out, because not for everything, but if you are doing it in an automated manner, then there is another law in the US, it's called TCPA, and that does require an opt-in for using it for marketing. And that carries really steep fines. It's like multiple $100s per text messaging. And there have been multiple cases where people were just like waiting. It's like, oop, 1, 2, 3, 4, 5. Oh, okay, now I'm going to sue. So that's, if you're doing text messaging, I would button it up well. So that's on the marketing side. The other good news that I can tell you is that unlike in Turkey, you don't have to like pre-register. This whole like now with COVID, we're like registering everything and everywhere, and everything is just pieces of paper going to regulators. So you don't need to register with a US authority unless you are considered a data broker. If you are a data broker, and a data broker is defined as a company that collects and sells to third parties personal information of consumers that they don't have a relationship with. And the definition of sale is a little bit misleading. It's very broad. So if you are if you are an intermediary, if you are sourcing personal data and then sharing it with third parties, and those third parties are not your service providers, they're not your, to use the GDPR term, your data processors, then you may need to register. You may need to register in California and in Vermont. And the other thing to think about is if you are in this position of data broker, that's also something to talk to legal counsel about, because the FTC has been interested in data brokers for a really long time. They published, and the US Federal Trade Commission, which is the sort of federal privacy regulator, they published this paper on regulators in 2014. Paper was very stern and then never went anywhere. Now the FTC, the leadership of the FTC changed. The FTC leadership is very proactive, and they've already voiced, their intent to kind of look at data brokers. So that's something to think about. The other kind of general point that I would make before I dig into California specifically is that the FTC, which again is something to look out for because they are becoming a lot more active, is they have been in the more recent enforcement actions that they have issued, looked at substantive privacy compliance, like a privacy program, like having, having a person that's responsible, having information security measures that are documented, having an audit procedure, having a privacy policy, and not the disclosure, like internal policies and procedures. Obviously, the larger you are, the more this is relevant for you, because similar to the principle of accountability in the EU regime, right? The bigger the company, the more complex the data, the more kind of paperwork the FTC is going to look for. But it is something to think about because it's more kind of substantive compliance as opposed to specific like ticking boxes. It's kind of like more conceptual. So that's kind of the general thought on the US. Take a step back for a second. The US does not have a federal privacy law. Maybe I should say yet, because we are seeing a lot of activity in this area, and we are seeing multiple bills issued for privacy laws. There was one that was issued just yesterday that has a bunch of GDPR principles in it. And so It's complicated on whether or not we get a federal law in the very near future, because there are a couple of issues that are very difficult for the two sides, the two political parties to align on. But there is, on the one hand, no federal privacy law. On the other hand, the FTC is enforcing, and the FTC is enforcing, again, a lot with respect to disclosures, which I'm going to talk about. There are a bunch of federal laws that are sector specific. So if you are a company that falls in that sector, if you are in the health sector and you fall under HIPAA, if you are a financial services company, you're fintech, because the rules were just amended. If you are a fintech, we have Graham Leach Bliley, we have the Fair Credit Reporting Act. If you deal with information of children under the age of 13, we have COPA. So if you're an education institution getting support, we have a different law. So that's definitely something to think about. There may be laws that are already governing your activity. If not, then you may fall under scope of the CCPA. The CCPA is the California Consumer Privacy Act. It's the first comprehensive data protection law in the United States, went into effect in 2020. It is going to be joined by Virginia and Colorado in 2023, and probably a number of other states, because a bunch were very close last year. In order to fall in scope for CCPA, you need to be deemed doing business in California. That is a very, very broad concept. And so if you are planning to launch, activity in the US, California is a huge economy in the US, and generally definitely worth checking whether or not it applies to you. If it does apply to you, what does this mean? So first I'll start with the good news, right? Like the cross-border transfer piece, I don't have, I can talk about it all day and all week, but I don't have much to say on the US side. Like the US does not regulate or prohibit cross-border transfers from the US outside the US. And so while that might be, I actually don't know in Turkey whether or not that would be, if you're a Turkish company, does the transfer from the US to Turkey consider like a reverse transfer and it needs to comply with Turkish law? It might do. But from the US perspective, we don't regulate, almost never limit the going to the US. From Turkey to the US, you have the same normal issues that you're dealing with respect to consent. And I think consent lends itself to disclosure. So we saw there was a guidance or opinion recently from the European Data Protection Supervisor, from the EDPS, about using consent as a cross-border transfer mechanism. And one of the things that they said, which I think just is pervasive, is one of the key conditions for consent is transparency with respect to the transfer, with respect to the processing that's going on overseas. So that's a good segue to what are things that you need to think about and do when thinking of or launching, or you've already launched in the US. The first thing is you want to look at your privacy notices. It is very, very likely, highly likely, you will need to revise them, not only because the CCPA requirements are more detailed than the Data Protection Directive requirements, and we also have gotten guidance and enforcement from the California Attorney General that talks about how specific the notices need to be, what they need to include. So number one, and there's very California specific things, like you need to mention categories of data which are, California specific and California specific rights. So number one, you're probably going to need to amend your privacy notice. Number two, you're probably going to need to add privacy notices that you don't already have. What does that mean? California requires something called a notice at collection. It is kind of similar to the GDPR first layer notice, and you need to have a pop-up or a little call out or something when you're processing the information, and that can link to the bigger privacy notice. So you're probably going to need to add notices of collection and mobile devices offline if you have retail stores or whatever. You probably need to add a notice of opt-out, which is if you have a sale. I'm going to talk about that in a second. That's a California unique concept. And if you have any type of loyalty, membership, rewards programs, things like that for consumers, this may be something called a financial incentive, and you may need a specific notice for that. So that's one. Probably need to amend your notices, probably need to add more notices. For consumer rights, what's called in GDPR land, data subject rights. Number one, CCPA requires a process of authentication and verification. It's kind of implied in GDPR, and there's fines about, not, sending the information to the wrong person. But CCPA there are criteria as to what that verification needs to look like, and it needs to be documented. So that's number one. Number two, you need to probably look at or improve your consumer request process. CCPA requires specific methods for submitting, which GDPR doesn't. Like in GDPR, you can just have an email address. Under CCPA, that's not enough. You need, in most cases, you need a toll-free phone number. For the opt-out right, you need a web form that you need to submit. You also have a right that doesn't exist in GDPR, which is the right to opt out of sale. Sale is a situation where you share information with a third party that is not your service provider. Let's say they do marketing. And then you need to give the individual the right to opt out of this sharing. You need a web form of that. And that also applies to cookies. So third-party cookies like Google Analytics, like targeting cookies, those could be sale, and you need a web-based, like a cookie management platform to deal with the opt-out. You also should look into, when you're doing that, there is a standard that's promulgated now called the Global Privacy Control, GPC, and that is going to be enforced by the Attorney General. One of the proponents, one of the people that is behind the standard is the new head of the California Supervisory Authority. So that's definitely going to happen. And then to round out, and then I see if you have any questions for me, is CPRA. So CCPA is super new, but has already been amended. It's going to be amended by a law called the CPRA that's going into effect in January of 2023. And that adds a bunch of things from GDPR. You have requirements for service provider agreements, right? Like the Article 28 DPA, not quite like it. It's got other things that it doesn't have. So you're going to need to amend your Article 28 DPAs or your Turkish equivalent of that, or have a US specific one that deals with things. There's mandatory employee training that you have to do for CPRA. It has a retention limitation, same as with GDPR. You need to have retention policy, retention schedules. You need to delete information when no longer necessary for the purpose. And you also need, in certain situations, to conduct DPIAs for certain processes that are more risky. So even my sort of summary line is that even if you are aligned with GDPR and you've got a lot of things in place for GDPR, it is very likely that for California, you're going to need to do a bunch of other things that you didn't need to do before.
So for California, just before you finish, ask you a question. So for California, would it be only necessary if you are selling goods and services, or having, for example, a subsidiary, just a dormant just a kind of a holding company registered in California would put you in as a under obligations to comply with CCPA?
So there are a bunch of options for falling in scope. First of all, the precondition is that you need to be processing the personal information of California residents. So if you just have a shelf company or something that doesn't touch data, then no. The only sort of caveat to that is there is a structure, and it's changing in CPRA a little bit, where if you are a group of companies and you share branding, right? Like you have the same trade name and there is some sort of ownership structure. Right now it's 50%, but CPRA is changing it to 40%. Then sort of one entity could like infect the other entity. but the overall, you need to be like, have some sort of business in there and touch data of Californians.
That's good to know. Thank you, Odia. So I think we covered UK, a little bit of EU, and a lot of also US. Now, let's talk about Turkey a little bit. We have two panelists from Turkey. First is Didem. Hi, Didem.
Hi, Celine.
Let me introduce Didem first. Didem is the Data Privacy and Competition Law Associate Director at Turkcell. Turkcell is the leading GSM operator in Turkey and also acts as the DPO of the company. She is an accomplished senior legal counsel specialized especially in data privacy, competition law, telecommunications, consumer and information technologies, regulatory affairs, compliance, and also she's leading the team. She's holding an LLM from Galatasaray University and is registered with Istanbul Bar Association. Didem and also John later on will, as two DPOs from Turkey, they have very distinguished position because as many of you know, Turkish companies are not obliged to appoint DPOs, but they are appointed as DPOs, and we will be hearing from them about their experiences and their roles and what they have been achieving in terms of global compliance work. She will be talking today about her role with them as a DPO in her organization and tell us about how existence of a DPO makes a difference in their organization and in their compliance efforts. She will also talk about registration requirements under Turkish data protection law. As many of you know already, that the deadline is 31st of December 2021 for all controllers, both foreign and Turkish controllers. And she will share us her insights about her experience and also generally what needs to be done to register with Verbis, the Turkish online registration system. She will then carry on about challenges when carrying out a global compliance project and share her thoughts on whether companies need separate policies for each jurisdiction, like Katie and Odia mentioned previously, or that can be done in a different way, for example, consolidating policies at once. Finally, she will share her recommendations for newcomers in the global arena. Didem, please.
Hi again. Can you hear me?
Yes, very nicely. Thank you.
Okay. I'm sorry that I attended a little bit late because I have some issues about joining, but I'm very happy to be here.
Thank you.
As you said, Selin, in our local law, it's not necessary to appoint a data protection officer in Turkey, and but it's not prohibited to either. Therefore, data controllers can voluntarily appoint a data protection officer similar to the GDPR regarding their data processing activities in Turkey. In this context, the regulations within the scope of the GDPR can be taken as a best practice example in terms of role and responsibilities of the data protection officer. So data controllers may appoint one of the company employees as a data protection officer, or they may refer an external person. And I strongly recommend that the duties and the powers to be given to this person and the responsibilities of this person will need to be clearly stated within the framework of a document such as a contract or commitment to be drawn up between the data controller and the relevant person. And appointing a DPO, even if the data controller is not obliged to, is very important when it comes to conduct a data privacy compliance program and build a culture of privacy. Much like when you embed privacy in your systems and technologies, when you embed it in your organizational culture, you end up with a structure that protects privacy by default while enabling you to use your data to its fullest potential. And the DPO is the key person in this process, I believe. By the way, some companies may call it DPO or privacy leader or whatever. The name is not necessary, I believe, but a DPO is not only a cornerstone of accountability, but can also help to ensure a competitive advantage. it is reasonable to assume, therefore, that assigning someone to manage the data protection risk and compliance makes good business sense. And in doing so, you will not only provide confidence to data owners, but all key stakeholders. And ultimately, organizations with dedicated high-level individual monitoring risks and compliance will gain a significant competitive advantage over those without. So in my organization, as a DPO and the head of the team, I focus on increasing compliance awareness and culture with proactive trainings. And I and my team are developing specific standards and procedures and taking and advising appropriate action steps to mitigate identified risks. And my main responsibilities are providing legal advice, drafting privacy contracts, managing the privacy program, advising on data subject requests, corresponding with data privacy authority, and education and awareness in a nutshell. And in my case, with my knowledge in the telco industry and my long history in the company, I can tell that I know all the processing activities in the company, so I can make decisions and advise about data privacy matters by taking into consideration of the business objectives. So I believe that's the difference I make as a DPO in my company. And about our second topic, as you said, as you know, data controllers in Turkey has an obligation to register the data controllers registry called Verbis, pursuant to Article 16 of the data protection law. And data controllers residing abroad are also required to be registered with the data controllers registry, so as long as they process personal data in Turkey.
So maybe it's worth to mention different than GDPR, anyone who processes Turkey-related personal data will need to register with the registry. That's the biggest difference, I think, when we compare it with GDPR, right?
Exactly. And one of the most important obligations regarding the data controllers registry is that a data controller must prepare a personal data inventory before registering. In other words, a type of data mapping of the data controller. And every data controller must make a true view its activities and determine the purposes of the data processing activity, category of personal data, their recipients, retention periods, and international transfers while preparing this inventory. On the other hand, controllers that are not established in Turkey must appoint a data controller representative under the DPL and the Regulation on Data Controllers Registry. The representative must be located in Turkey and must be either a legal entity or a Turkish citizen. And the representative must have the authority to receive and accept notifications and correspondence made by the Data Protection Authority on behalf of the data controller, transmit the demands made by the DPA to the data controller and submit the responses to the data controller to the DPA, receive data subjects requests on behalf of the controller and transmit the request to the controller, and also transmit the data controller's response to the data subjects. And lastly, perform operations relating to the data controller's registry on behalf of the controller. Mm-hmm. So the representative must be appointed with an appointment decision by the foreign controller, and the appointment letter must contain the powers of the representative as well as the full name and address of both foreign controller and the representative. And lastly, the appointment letter must be notarized and apostilled. Data controllers residing in Turkey and meeting the conditions for the registration obligation must appoint a contact person, which is another person. And it is important to note that the Turkish subsidiaries of foreign companies meeting the required conditions for the registration of Verbis must also appoint a contact person if such subsidiaries process personal data in Turkey. For data controllers in Turkey, the contact person is responsible for carrying out all the communication with the board and carry out all various proceedings. And since the contact person would have comprehensive and detailed information as to data processing activities in order to make alteration, a board has decided that a person could be appointed as the contact person for only one data controller residing in Turkey. For data controllers residing abroad, however, the board considered the difficulty of finding and appointing a legal or natural person with sufficient expertise in both data protection legislation and communication with the data controllers. And in this respect, the board decided to allow a legal or natural person to become representative of more than one data controllers abroad at the same time. As the representative is the actual person responsible for carrying out communication with the board, and the contact person appointed by the representative is one of the one who would carry the various proceedings, appointing the same contact for multiple data controllers was deemed appropriate by the board. It should be noted that since controllers have an obligation to receive, respond, and conclude data controllers' access requests and other requests relating the personal data in a timely manner and effective manner, foreign controllers that process personal data collected from Turkey must appoint their representatives without delay to prevent risks. Because as of today, foreign data controllers that collect personal data from Turkey who have not yet appointed a representative or registered with Verbis have exactly 8 weeks left to comply with this obligation. So if we compare DPO with data controller representative and contact person, the data officer regulated under GDPR is, as you know, is a person responsible for ensuring the compliance of the data controller with the personal data protection legislation and has important powers, acts independently from the data controller and reports directly to the senior management. On the other hand, the duties of the data controller representative and contact person regulated within the framework of Verbis regulation consists of establishing a communication between the controller and the authority and or relevant persons. So it should be noted that the data protection officer under the GDPR and the data controller representative and contact person under the Verbis regulation are completely different concepts, and data controllers should consider this difference when making such appointments in Turkey, I believe.
I would like to also ask your experience with Verbis. It's the online platform for registration, and should the foreign controllers be afraid of dealing with this, because it's, you know, it seems to be very far away for them. But do you think it's a user-friendly system? Obviously, it's in Turkish, so the language is a barrier. But apart from that, isn't it an easy process? How did you manage in your company that process? And what would be your experience on that?
I don't believe that it's frightened process. It's really easy. As you said, it's an online platform, and the foreign data controllers, as I mentioned, must have a data inventory before registering, because the registry system, in the registry system, you have to give your activities and category of personal data and recipients, retention periods, but in a categoric way. So if you have a proper inventory as a company, as a foreign company, it's easy to make these processes and to register to Verbis, I think.
Thank you. I will ask the same question later to Can and his experience on this, but thank you so much. So when it comes to carrying out global compliance projects, what were the challenges you faced, because we know in US things are different, in UK and Europe or any other jurisdiction, you're a global company, you're operating in different, and you're subject to different legislative requirements, heavily regulated in that sense. What are the challenges in managing the global privacy projects, and especially as a Turkish company, what were the main struggles you had personally?
First of all, I believe GDPR has the potential to set the standards for data protection globally, and it did actually. And we can say that it's the most comprehensive regulation. And we see that most governments have taken GDPR as a guideline in their respective data protection legislation. And it's not incorrect to say GDPR requires the most safeguards and consists of most data subject rights too. So especially global companies, organizations, either to choose or are obliged to comply with it already. Therefore, complying with GDPR could usually mean at least providing the necessary safeguards and taking measures arising from local legislations. So if an organization operates in too many different jurisdictions, I believe preparing a program framework procedure taking into account GDPR and applying it by making small changes changes only these areas according to the significant differences to the countries, if any, will be the easiest and most effective way in terms of operations. And in our company, we prefer it this way. So maybe John can give detailed answer to this question, because they are in wider countries with Getir.
So maybe John, now we can also start with you, and maybe we again turn back to Didem on similar topics. Let me first introduce John. Can Ertürkan is an innovative and tech-savvy privacy lawyer who's highly effective in developing creative legal strategies in his position. He leads the privacy team at Getir and handles GDPR, CCPA, and Turkish data protection law issues in 9 different jurisdictions where Getir operates. Prior to joining Getir, she worked as a privacy lawyer in different law firms, including his own practice, and he led privacy projects of clients from various sectors, including insurance, game, media, entertainment, and technology. John, we would also like to talk about your role in your organization and the challenges when carrying out a global compliance project. And we'll then hope you share with us your experience working with international service providers and the challenges you're facing when you need to comply both in Turkish legislation and these different legislations, the Turkish data protection law and other data protection laws. And when it comes to DPOs, obviously for the requirement of appointment of DPOs, Odia and Katie mentioned their jurisdictions, and you're operating in other jurisdictions as well. So operating internationally, are you required, do you see the requirement for appointment of DPOs, and what are the differences in your opinion in different jurisdictions? And when you compare different jurisdictions, what are the major similarities or differences in your opinion in terms of data protection laws? Please.
Thank you, Seren. Many thanks for the introduction and for the invitation. First of all, going last is, I think, really good, because from every panelist, I think my speech got shorter and shorter because they explained everything I was going to talk about. So which is a good thing for me, I guess. So I'm not going to go over everything they said, and I totally agree with what they talked about, especially Didem's words on the Turkish legislation. As for the DPO requirements, yes, you are right. We don't have a DPO requirement in Turkey, but it is a key thing because having a DPO or a key person in your company provides an extra layer of accountability, first of all. And within the organization, you need someone at least to lead the teams and to give the trainings and awareness, because without that, basically, the things can get out of hand pretty easily, especially if you're a tech company. Plus, even the Turkish legislation or GDPR, even for lawyers, I think it's a complex legislation because, I mean, it has very similarities with other laws, but of course there is like key differences between other laws because it really has big connection with tech industry. You need to understand the product environment, etc., etc. Whereas when you do normal kind of ways, so for example, litigation or something like that, you mostly deal with similar practices, or you have like current practice with the new legislations and everything. So the expertise is a key thing, and plus the line of communication, because when there's a breach, when there needs to be a go to the authority or any kind of communication within the company or outside the company, someone needs to lead this. Otherwise, it can get really, really messy, especially within the breach notification reporting periods or similar reporting periods within the EU law, within the Turkish law, and I'm sure Odia knows way much better than me, but in US, there are like way much complex breach notification requirements in every state with different aspects. So that's a key thing. Plus, I think having a DPO, it shows that the company is respectful of privacy, which is a good thing, because when the authorities came to your door, you can show that, look, we have a DPO, we have a team handling all the issues here. So we are aware of everything and we respect privacy. But when you don't have that kind of team or lead, it shows the lack of respect to privacy, plus the regulations and legislations. So in my opinion, these are the key things. And in my role, what I make difference is probably regarding the technology, because I never wanted to become a lawyer before becoming a lawyer. I always wanted to be a computer engineer, but both of my parents are lawyers, so they were like, you need to be a lawyer. So I went to this field of tech and law and like connected everything, which I think gave me a pretty much big advantage over over other lawyers, I guess. And this also helps me in the tech environment, especially in Getir, where I can connect other lawyers with like product teams and tech teams, because I can pretty much understand what the tech team talks about or what the product team talks about, which is, I think, a key thing for me. As for the key challenges operating in Turkey and being a global company, I think one of the biggest challenges to work with like big tech and like getting some support or technology from them is really hard, because it's hard to convince them that there is a Turkish data protection law, for example, because they are pretty much aware of EU laws and everything, but they don't really want to understand that we have a specific law and specific requirements on that. And plus, when you have a company which operates in like 7, 8, 9 countries, the global agreements can be like 6 different agreements, because one for CCPA, one for SCCs, one for Turkey, one for cross-border undertaking. So it is a really challenging thing to do. But I think it's useful in this respect to provide the vendors or big tech companies some key differences between GDPR or like CCPA with Turkish law. What we are doing is this, basically like providing them with like translations of the law, some key summaries of the differences between the different legislations, which really helps, because at least with that, they can understand, or they try to understand the law and everything. I think the third thing is, like, at the beginning of this year, we were just a Turkish company, and it was hard for us to like sit into a table and negotiate deals. But now that we are a big brand also in Europe and hopefully soon in US, it's getting easier, and it will probably get easier and easier every day. But of course, this is not the case for every company. You can be a small or mid-level company in Turkey and wants to compete with like competitors around Europe. So you need to go to big tech and get some help from them regarding technology or infrastructure or whatever. So in that sense, I guess, yeah, I mean, just explain them that what we have and try to make them understand. I know it's hard. I'm dealing with this almost every day, but it gets easier. And when you have some kind of practice built already in the past, and then you can use that with like new companies, which is really, really helpful in my opinion. As for the differences and similarities, I mean, all of the panelists talked about like the key differences and similarities. I'm not going to go over all these details, but especially for us, like privacy notices is like similarity with EU, and for CCPA part for the US as well as right now. But the biggest difference in my opinion is that most of the Turkish companies base their privacy notices on verbis, the registry purposes and everything, the categorization and everything. So it's like when you go to a website, you see same categories, same purposes, whereas in Europe or UK or US, they have this flexibility of having their own categorization, own purposes, which is, I guess, the right way to go. But as Turkish people, we don't want to, I think, go over like too much work, do like many work. And of course, like the companies are afraid of authorities' approach on this. If, like, for example, they take a customized approach, the DPA can say, no, you can't do this because we have already provided you with the list of categories and everything. So that one of the key similarity and difference, I think, lies in the privacy notice requirements. Other than that, of course, the same goes with the records of processing activities. Like in Europe, it's not, you don't need to base your records of processing onto anything that ICO or EDPVs or anyone published. You can, of course, use their examples, guidance on what you do, but you're pretty much free to do whatever you want as long as you have the accountability and as long as you document everything in a right sense. Whereas in Turkey, I think all of the inventories are the same, like, you know, like all categorization and everything. And in my opinion, it's not a good way, but it's the easiest way. And we like it that way, I guess. So I can definitely say that that's also one difference. Another difference is, especially Odia and Katie talked about accountability. We are also talking about accountability in Turkey, but it's not something that is written in law. Just like the former EU legislation, we don't have accountability. We are talking about accountability, but we don't have accountability principle in Turkish legislation, which is, I think, a really, really challenging thing, because if you are not obliged to have some kind of accountability, whatever you do, it doesn't really matter because you're just showing off your policies and everything. But if you are not accountable for what you do, or if you don't really have to, let's say, document everything and like show that you have accountability, it's just a show for the, you know, customers, in my opinion. So that was a big difference, in my opinion, because when we are in EU atmosphere, especially, we had to have some kind of accountability. We had to document everything, DPIAs and everything. So it's really different atmosphere. But what was surprising for me is, maybe Katie or Odia would agree with this, but I was expecting more awareness from the companies when we launched in EU, UK, but that was not the case. Like when we sat with like vendors or like suppliers, they were pretty much similar to Turkish companies. They didn't have much idea other than the big ones. They didn't have much idea. They couldn't identify who is processor, who is controller. I was always like talking with them, explaining what is sub-processor, what needs to be done, etc., etc. So that was like really, really surprising for me to see that even in EU, UK, they didn't have that kind of awareness that we as Turkish people expecting in EU, because like EU law is like so modernized, so advanced, so they should be able to, you know, have more awareness, but that was not the case, to be honest. As for the policies, we take different approach than what DDEM and Turkcell takes. We have special customized policies for each EU entity, for example, because we at the beginning we thought about having a single policy and then country measures attached to the single policy, but then we looked into all the local jurisdictions and differences between those, plus having like local translation all of these. We decided to go with different EU local policies even for EU entities. But that will change in the US, because in the US, I don't think it's really necessary to have like different policies for at least till 2023 for Virginia and everything. And we are not going to go launch in California yet. So soon maybe, but right now in US, we prefer to go with one single policy, whereas in EU, we have different policies for each country that we operate right now. Same goes for the employee policies and everything. And within that respect, the most key difference for us was especially direct marketing rules in the EU was really different between all of the countries. Retention periods were really, really different in all jurisdictions. In that sense, UK was the already most pragmatic and most business-friendly country that we launched. And I love UK for that, to be honest, because I mean, who wouldn't love that? But of course, after seeing US laws, that changed a bit. Now my favorite is US, at least till we launch in California. So yeah, I mean, these are my points, I guess. And one last thing about global privacy programs. Like I said at the beginning, like interjurisdictional comparison of privacy laws is really key. Especially when you're launching from some like Turkish companies, it's better to have, you know, like gap analysis of Turkish law and then GDPR, so you can already see the difference and then build your privacy program on that. But pretty much, I mean, I don't want to go over everything the other panelists say. So I mean, this is my notes, but if I missed anything, please let me know so I can go over again.
No, thank you very much. It was really nice to hear your experiences and in going through this amazing time in your organization. Maybe Odia and Katie can add something, especially maybe an advice for Turkish companies when dealing with international service providers and negotiating things with them. As John mentioned, it's not easy when you're just a startup or in the beginning of your journey as a company. But when you get bigger and bigger, obviously you have more negotiation power and maybe ability to convince the counterparty on certain contractual provisions. What is your experience and what will be your advice when it comes to dealing internationally for Turkish companies?
No, I had a couple of points I wanted to pick up on actually, and that people said, but I'll answer the question first rather than letting that get forgotten. It is very difficult when you are particularly growing and you're still relatively, you have quite low bargaining power, to impose any kind of your own data protection terms, your own DPA on the bigger service providers. It's just not going to happen. It surprises me, John, that that you did find quite little awareness of data protection rules. That's becoming less and less common in my experience. Maybe that's just the kind of contracts that I get asked about. It's just everyone knows already. But there is increasing recognition of the requirements, and I mean, I have had a few negotiations where I've had to explain, controller processor roles and similar, more than a few actually, but there is an awareness, at least I think, that they're needed, even if some people are still getting to grips with what that actually means in practice, and who does it apply to. So it is more challenging, I find. Odia, maybe you can speak to this about the big US service providers. Obviously the very big ones have got their whole program sorted, they've got their terms, and they will roll them out whether you like it or not. So then there may be a bit of risk analysis if you're not happy with what those terms say, really, and it's just taking a sort of risk-based approach and on your position on whether you accept them or not. But yeah, sometimes I find with some of the big US providers, not the really big ones, but the bigger ones, sometimes don't have the understanding of these kind of onerous and annoying rules, say around transfers to the US that have come up recently, and transfer impact assessments that we're having to do now when we're sending things to US service providers. That is a challenging conversation sometimes. I don't have any magic answers, I'm afraid.
I don't know, can we stop with the part where the US is the best? I don't know, I thought that was the best takeaway.
Sorry, I didn't want to lay
I think a couple of things. So the easier piece is the DPA, right? The agreement that you need to enter into. That is sort of a learning process here a little bit. And also it's not super helpful for us that between CCPA and CPRA, the requirements for service provider agreements changed dramatically. And so now you have all this so I have a CCPA thing, but it doesn't include things, and then you have to improve it. So that's frustrating. But I think in order to if you want to put together, if you're a Turkish company and you have an Article 28 DPA that satisfies, the rules of the Turkish law and GDPR, amending it in order to account for the US laws and even use the same format. And even use the same format that incorporates the new EU standard contractual clauses, that's not that hard to do, and we've been doing that. So we have, we've made this format for clients where it's like a DPA that references the clauses and builds in US data protection law. That part is not hard to do. It's a lot of work, but it's okay. The cross-border transfer piece, is complicated. I, just got an email from a client I am really frustrated with this GDPR compliance thing, and I'm just a small company and whatever. I'm like, yeah, I don't know what to, yes, agree. I can't really help you. But the Schrems situation, as with respect to US service providers, is extremely frustrating. And not to cut out all the other editorial. It's just, in practice, very frustrating. And in a lot of cases, companies on both sides, I mean, obviously, if you're a US company in the US, that's where you are. You can't not be there. In a lot of cases, companies in the EU and outside the EU, use US-based providers for a reason, and it is not practical, feasible, not possible in the immediate term to not use them. I know that a lot of people, some of whom are my friends that are involved in this, basically say, don't outsource. I'm like, okay, well, we can all, live in a cave and, go off the grid and put bake pita in the sun, but we don't do that. So I think the second best thing to that is, even though it is not, it's not 100% in line with what the EDPB is saying. The EDPB did leave a sliver crack of hope open with respect to the risk-based approach. And I think that the best thing that you can do is, one thing is clear, and I think that, I agree with everybody on, is that you need the transparency, right? Like, you need to understand what's going on. I had clients ask me, what do you mean I have to look at my sub-processors? Like, what do you mean I have to, I don't know, like my processor has sub-processors and I have no idea. Well, I get that that's the case, but that's not, I also understand why that is a problem. And so we need to figure out how to make that whole chain more transparent. We also need to be aware of what exactly is the data that is being handled, right? In some situations, the data is not that high risk. The sub-processor has a subset of that data that is not high risk. And then, you can sort of work around it. There's a really interesting guide that was published by the Danish Data Protection Authority a couple of days ago on supervising processors, and they assess the data and they say, according to the level of data, this is how you supervise. And then they say, well, check what the sub-processor does. If the sub-processor has a subset of this, then okay, it's a different point system. So I think that part of, okay, we've got to at least know what's going on. We need to know what country it is. We need to know, what the protections are. We need to take into consideration the nature of the data and the transfer. All of that is true. And all of that is things that we can do now. What can we not do now? We can't change FISA 702 in Executive Order 12333 other than, praying or something. I don't know, those of you that believe me, maybe we can add FISA 702 to all our respective prayer lists. But besides that, I mean, we can, we do what we can.
I'm with you on that idea. I just wanted to pick up on a couple of points unrelated that they were coming to me as the other panelists were speaking. To cover off on the registration point, we don't have registration requirements in the UK. I know we did actually prior to GDPR coming in, as did some other member states. No one does anymore. But in the UK, there is this data protection fee, and you need to register as a fee payer if you have any kind of establishment UK company. And if you don't, they'll come sort of looking for you and sending you a letter. So I just thought I should,
like the TV license.
Yeah, it is exactly like the TV license. So it doesn't sound like it's anywhere near as onerous as the registration requirement you guys have though. And then the other thing is about the DPO. Completely agree. It's really important to have someone who leads, is responsible for the privacy program, who can get the business on side and actually be aware of when someone's planning some risky processing that they don't even really realize is a problem. Someone in marketing comes up with a great idea. Just be a bit careful if you're going to call that person your data protection officer. That has specific implications for their duties under GDPR and UK GDPR. It means, for example, they have to report in to the highest level of the organisation. They have to be given sufficient resources. They cannot be sort of dismissed or suffer any detriment as a result of what they do. There are certain sort of implications in terms of what that means for their role, even if you're appointing them voluntarily. If you call them data protection officer for European or UK purposes, it means something. So you might, if you don't want it to mean something, you don't need to appoint one, you might want to call them something different. Those are my additional points.
Thank you. We have a couple of questions that we can address in a minute. But maybe Didem, is there anything would you like to add to the latest discussions?
Maybe I can add.
Favorite jurisdiction, like John.
Maybe I can add something about data compliance programs because it's really important to conduct a data compliance program within the company. And I think a few things are the top to make an effective data privacy compliance program. The first of all, it's the most important step to get the support of the company's top management, I believe, because the importance given to the program by the management is essential for the program to reach whole company and for all employees to adopt the program. Because during the data privacy compliance program, it's very common situation that the teams does not see this issue as their work, therefore they resist making an effective contribution to the program, or they do not want to spend time on this issue. And I think that's the case for all the companies. And in this case, knowing that the top management wants the program to be embraced by all employees is the most important tool to make the teams really embrace the program. And so this is my first recommendation for getting the management's full support. The second one is to establishing a data compliance committee within the company to report the scope and the steps of the program regularly and record the committee's decisions. Reporting the committee's decisions are important for an effective compliance program management and creating a company memory. And the last one is, of course, the education. Training and awareness of employees at all levels are essential for the success and sustainability of the compliance program.
Thank you. Thank you, Didem. Actually, John's comment on the level of discussions with international service providers was very interesting to know. But obviously, Turkey is new in data protection arena. We enacted the law back in 2016. Before then, there was no specific law regulating data protection law in Turkey. So we were like the last comers, but we had a very quick entrance. And now, maybe for the ones who are not very familiar with Turkish legislative environment, there is a GDPR level law, data protection law bill being prepared. So it is planned to be enacted, hopefully in the first half of 2022. So this is very important, obviously, for many reasons for Turkish businesses, for adequacy and for many other aspects of international data privacy matters. But this is being taken very seriously, and hopefully some of the differences when it comes to processing of data or international data transfers will be solved when we have this change in the legislation. But obviously that requires a lot of effort and hopefully also a lot of feedback from the businesses who are operating globally. I will go back to some of the questions, but I also want to, especially from Katie, want to hear this new also bill. You talked about it very shortly, but maybe you can a little bit help us understand, especially what are this new approach promising to the businesses, because for Turkey also international data transfers is a very complicated and a non-solved matter. And I believe English approach and ICO's support in this new pragmatic way of formulating the matter may be also very helpful for Turkish authorities, and maybe kind of inspire them to have a more pragmatic approach, allowing Turkish businesses to go global much easily and to compete with international players. Could you please also a little bit add some comments on this new, especially the impact assessment tool and the different categorizations, especially different personal data levels that are differentiated when it comes to international transfers in the new bill, proposed bill?
So, this is in relation to international data transfer,
Yeah.
specifically. So yeah, the pragmatic approach. There's a couple of different consultations that are relevant here. There's a UK government one, and there's an ICO one. And the UK government one is, and that's the one where they're talking about making quite broad ranging changes to UK data protection, or some of the ones I've touched on, sort of making it easier to rely on legitimate interests, changing some of the requirements around cookies and tweaking sort of direct marketing rules to make, again, it's all sort of, the idea is to make it more business friendly, to facilitate or make it clearer what the legal bases are in relation to artificial intelligence and research and development. So again, it's all supposed to be very innovation and business friendly. In relation to data transfers, there's sort of key points to note, especially where you know, under Turkish law, there are sort of restrictions around prior authorizations and consents for transfers. The UK approach from the government is quite innovative, or what actually, in a way, it's almost going back to what we had under the directive, which is that potentially they might consider allowing organizations to come up with their own safeguards. And if they think they're appropriate, use those instead of the pre-approved standard contractual clauses, or what we're going to have, maybe potentially this IDTA. So again, it's all supposed to be, everything is very bespoke to the business, and you can make your own grown-up decisions about what safeguards you think are right. Presumably there'll be a baseline. You obviously have to be, you know, convinced that they're appropriate measures that you're putting in place to safeguard the transfer, but you won't necessarily have to follow a very prescriptive contract, and you certainly won't need to take any other steps like get consents or prior authorization. So the main sort of move is, you know, you're allowed to bespoke your program for your particular context, including your transfer safeguards. And you know, that's okay, that's allowed. You can make sensible decisions, you document them, you back it up if it gets challenged, but that's the expectation going forward. So that's the government consultation, and that's obviously quite a big change. What's coming more imminently, we're hoping, is the ICO consultation on the draft documents, and that's the ones I mentioned. So the IDTA is the UK standard contractual clauses, the TRA is the UK transfer impact assessment equivalent, and the UK addendum is the kind of, as this sort of short form document, will sit alongside the the EU standard contractual clauses if you want to use those instead. Those deal with the law as it is now, so not this kind of idea of bespoking your own document. That we're not there yet. I don't know quite when that, or if that even that's going to happen. So it's not in bill form yet, that government proposal. It's you know, they're asking for feedback. The ICO documents deal with the fact that you do need to have a standard form safeguard in place, unless you can apply one of these derogations, but they're only supposed to be very occasional. So I won't go into detail on those. Unless you can apply one of those, you basically have to use standard form safeguards as things currently stand. And obviously the standard contractual clauses are the most commonly used of those. In terms of this sort of transfer risk assessment approach, they talk about different risk levels specific to the data and the actual transfer in question. So if it's inherently low risk, medium risk, high risk data, you proceed from that as a sort of starting point as you go through. If you work through these different flowcharts that they have set out in their transfer risk assessment, which again is still in draft. So everything kind of starts from the risk level of the data. That's a really important thing to bear in mind, rather than the more European approach is to think, when I'm exporting data, where am I exporting it to? Obviously you have to take into account what data you're exporting, but the most, I read it as the most important thing being the law and practices of the country that you're sending it to. it's a different starting point. It's quite a different way of looking at it.
Yeah, thank you. Odia, before I know you need to drop off a little early, so there are a few questions that let's mostly actually it's about international data transfers for multinational companies working in Turkey. They find it a little obviously complicated and difficult to cope with the situation because of the issue that we don't have adequate countries yet announced by the Turkish Data Protection Authority, and that complicates everything even further. So the consent, which is different in Europe, consent becomes the first to go solution. But obviously it comes with many other obstacles and consequences. So the question here is, what is the best practices and guidance for international companies operating in Turkey to manage the consent management, especially in this highly digital world with the use of global cloud resources to manage business solutions? We're hoping that Turkish authority will release a list of adequate secure countries to minimize the impact. So yes, that's been in the agendas for a long time. And then the other question is, I am transferring data abroad due to the law. Controls have to obtain consent, the same problem. This makes things hard. The term adequate protection is not clear. So there is this similar restriction in China, China's new data privacy law. Considering the nature of digital data, is it necessary to redefine the boundaries about the particular issues, and what can be the solution? So we are all looking for solutions, not easy to find, but maybe you can, from your experience internationally, you can also a little bit point out what could be solutions, or what should be the biggest concern for international companies.
I think the first thing you should do is you should tell the KVKK that Sean said that the US is the best and therefore it's adequate, and then we're good.
Yes.
So we solved the problem and we're good. So consent, I think the deal with consent, what I can say is that, and going off again, there have been a few, I've been looking for like rays of light, you know, out of the different kind of EU court and EU authorities on this. And there have been a couple of opinions on specific transfers that they're not completely helpful, but they sort of are instructive, right? So there's been a couple of opinions. One of them was the ICO, one of them is in Jersey, regarding, for example, reporting to the SEC, right, under a derogation. And the recent opinion that I mentioned by the EDPS on consent as a derogation. And what I think we can learn from that is that in order, and I think this is true, you guys correct me because you guys know how to do consent for Turkish law better than I do, but I think one of the conditions is transparency. And so what you need to do, and this is a work in progress, even with respect to the Schrems TIA, we need more transparency from the big service providers and from the small service providers, right? You need to have a good picture of what is the data, where is it processed, what are the, information security set up, what are the supplemental measures, do they have, have they gotten national security letters, like all of that stuff. And unfortunately, formally, you need to do that with respect to your subprocessor and subprocessor and sub-subprocessor until you reach Middle Earth, right? And so that's, difficult. Hopefully we will get this in process and start getting this transparency. But obviously it's more important to prioritize this when the information is more sensitive. So I think the first thing to do is kind of figure out, understand your transfers and, put in place the clause, in Europe, you need the clauses or whatever. And then with respect to consent, so first of all, you can try to present, and that's what the EDPS said. They're like, oh, you're using the deal was, the case was about ENISA, right? The European Agency for Security. And they had a newsletter, and they wanted to use consent as the legal basis for using a US-based provider for the newsletter. So it wasn't just subscription to the newsletter, it was using a US-based provider for the mailing as a derogation, right? Consent is derogation, which is similar to consent is consent. So basically what the EDPS said was, one, it needs to be clear what is the deal, right? What is the scope here? Who is the provider? What is the provider doing with the data? How is it protecting the data, right? And then it said, and that, by the way, we also saw in the WhatsApp, not the WhatsApp, the DPC Ireland Facebook decision that is talking about 6.1b, right? The necessity for a contract. And they're saying, oh, if you understand the whole scope of what is going on in that situation that talked about targeted advertising, if you understand that targeted advertising is part of the deal, then it should be part of the deal. Now we'll see whether or not that sticks with, you know, other supervisory authorities. But the concept is, okay, if I, as the consumer, understand what's going on, yes, I'm going to put it on, you know, whatever, I'm using X provider and they have another subprocessor, and that's the deal, and I understand it. I think that's the first step. And in that, you need cooperation from the US providers. I know the small ones are working to do it because, you know, I've heard from a lot of them, and the big ones also. So that's number one. And the other is, you know, the consent needs to be granular. So for example, in the EDPS decision, you need consent for the newsletter, and then you need a separate consent for the using of the provider that is in the US. And so I think in this situation, you need consent for the processing, and then you need a separate consent for the cross-border transfer. And as long as you spell it out, I think that's, you know, that's I think the best as you can do. The other example that I know has been done, and I've seen this done, like in Germany, I know they do it, is for consent for cookies. So there is a consent for the deployment of the cookie and the consent for the sending of the cookie data to the US. It's like a separate consent wall situation. So I think transparency and then granularity, I think, is the best that you can do. It's not foolproof. And I don't know, is consent revocable in Turkey? Like you consented to the transfer of your data,
obviously, yeah.
Then you revoke it, and then it's the same as in the EU, like it applies from that moment forward.
Yeah.
So, okay.
Same rule. Same rule. So before you go, just one more question. We know that for non-EU companies, so about the standard contractual clauses, so there's an expectation for non-EU companies a new standard contractual clause. So what is the expectation? What should be the expectation for non-EU companies or controllers for that? Will there be more conditions, or do you think it will be easier? Do you have any expectation, any guesses?
So I think that, so right now we already have a lot of clauses, and they are supposed to be modular and user friendly, and they are modular. Okay. There is also, we heard from the EDPB, Katie was talking about this originally on the scope of transfer, that apparently the preview is that if you are an Article 3.2 controller, right, a non-EU controller subject to the GDPR under Article 3.2, then a transfer of information to you is a transfer, and it requires a transfer mechanism like clauses. And it's not the clauses that are already just were published, and we're going to get new ones.
Exactly.
Nice surprise for everyone, wasn't it?
And it's like,
surprise.
I don't know if, I mean, the concept itself is not that surprising. I mean, you know, I know for a fact that actually the main companies that are non-EU that are using clauses are Article 32 country entities, because nobody else,
anyway,
you know, they don't, it's not even top of mind to do it that way. And, you know, and the ones that are subject to GDPR are mindful, and there have been a lot of uses under the old clauses of the clauses backwards, where the importer is actually taking on the exporter role, right? Because they were the controller. So we were doing like clauses upside down because we said, okay, well, we have nothing else, and we're taking on, you know, the obligations. And so that's better than not taking on obligations. And, you know, and this was supposed to have been resolved, and arguably was resolved. If you read the clauses, some of the recitals seem to be able to facilitate an export by a non-EU entity. But now the EDPB is saying, no, actually, no, we didn't mean that. So it's something else. So it's different clauses. I don't know.
I expect that those clauses, they are intended for use, as you say, Odia, where the recipient is already subject to GDPR on an extraterritorial basis. And therefore, I'm hoping there will be basically a light touch, a version of the existing or the new ones that were published last year, because arguably you don't, well, having said that, it depends whether you want sort of contractual enforceability in terms of the contents, but strictly speaking, you don't really need all the stuff that's in the EU standard contractual clauses about the principles of the GDPR will apply and the importer will basically act as if it's subject to GDPR itself, if it already is subject to GDPR itself. So it might focus more on the transfer impact assessment requirements in those standard contractual clauses and just be fingers crossed, a light touch version of the ones that everyone's scurrying to put in place at the moment.
Fingers crossed.
Which we will need to put in place, right? Because we just did them. But
more work for lawyers.
Yes, indeed.
Don't print them out, so it'll be at least, not, we want a zero carbon swapping out of the SECs by 2030.
Thank you. So, John, would you like to answer the question about the technology improvements? The question was, GDPR and GDPR-inspired legislations are in effect since 2016. The progress in terms of combining laws and technology. I believe we have not seen expected progress. Do you agree on this? If yes, what are your expectations in technology improvements in next 1 or 3 years?
I totally agree. Even GDPR is like, I think the trendsetter in privacy with regards to the technology right now is the big tech, because they are having this huge fights between each other and try to block their, technologies, like tracking technologies and everything, especially Apple's new IDFA technologies and having this privacy rules around the App Store apps is a huge thing, because until then, no one had a big impact on the technology side, especially the mobile part. The websites were always kind of compliant in a sense, but the mobile atmosphere just changed it with this new Apple's introductions into privacy, and they are trying to build this new privacy company kind of trend around the world. But I think the GDPR, they have good guidelines. UK is also following that as well. Whereas I think Turkish legislation is more focused on practical areas rather than technology, even though we see some new presentations about cookies from the Turkish DPA. Which I think they had some kind of videos, some explanations and everything, but we need to follow that example of EU and UK, I guess, in that sense. But in my opinion, the law will never be as fast as technology. That's too far to think about. But like I said, the tech companies, if they build these new challenges around each other, try to block their technologies, and then I think we will have more accountability, more visibility on what's really going on, especially with, I think iOS 15, Apple is now introducing even more accountability, where you can see which app uses which data and where does that app transfers your data, etc., etc. So like right now, I think Apple is doing more than what all the regulators needs to do. But of course, they are not doing it for privacy. They are doing it for their gain and to have, some kind of advantage over rest of the big tech, such as Facebook, Google, etc., etc. So, but in the end, this fight really helps the privacy gets more important, and especially helps to have us as people control over what's really going on, or at least see some kind of changes in the area that regulations couldn't have that effect in, especially the mobile atmosphere where Getir and big delivery companies are right now operating under. So for me, that technology, like I said, will never be catch up by the legislation in that sense. Maybe in 10 years, but I think we have bigger problems on our hand with regards to regulations, even for the EU legislation, than technology. And like I said, the big tech is doing all the work, hard work for us right now in that sense.
Katie, anything you would like to add?
No, I mean, I agree. I think that the market, the gatekeepers, really, the tech companies like Apple, you know, they're obviously setting expectations for apps that are going to go on its app store. So around privacy notices, around access to data, and prior consent to those things. That, as you say, you know, that it has almost more impact than some of the regulatory action that we've seen. You know, it particularly some of the big supervisory authorities seem to want to take their time in enforcement action against some of these companies, presumably because they have, you know, because of the lawyers, and it's so open to challenge. There must be an element of, first of all, not wanting to get it wrong, and also, you know, not wanting to kind of get on the wrong side of them. So it's challenging in terms of enforcement action. So yeah, we do have to kind of take the lead as some of these gatekeepers. And I think the European legislation, sort of the Digital Data Governance Act, the Digital Services and Markets Act, they're looking at regulating some of these big tech companies as a result far more heavily, and using competition tools as well because of their market dominance. So yeah, that's what we're probably going to be seeing.
Yeah, Didem, you are also a big technology company. I mean, apart from being a GSM operator, you are developing technology. And do you think legislation can be a hurdle for a technology company, or can because things change so fast? It will be up to the technology company to really self-regulate when it comes to these issues. I think I missed them. Okay, so well, if she comes back, we can hear her. But our time is up. Thank you so much for everyone today. It's been a pleasure. We discussed so many topics, and I hope all of our participants also enjoyed our discussions. As I mentioned before, we recorded this webinar, and it will be available on our law firm's LinkedIn pages. If you want to learn a little bit more about Turkish registration requirements or representative requirements, we have a very short presentation for that. We will make it also available for you who still need to comply with the registration requirements and complete the procedures by the end of the deadline. So this was our first KP Talks webinar, and we will be waiting we will be having further events, and we'll be very happy to have you back here. Thank you again for this lovely talk. For the ones who are in US, have a lovely day, and for the rest of us, have a beautiful afternoon and a nice evening. Take care, and see you soon back again here. Bye.
Thank you.